the federal government of Nigeria unlawfully kidnapped and abducted him in violation of international laws and his fundamental human rights. According to the Supreme Court at page 20 of the judgment, I quote again, in purported execution of the unfairly obtained and illegal order of arrest of the respondent, the officials and agents of the appellant traced the respondent to Nairobi in Kenya, violated his fundamental rights, kidnapped, abducted, and extraordinarily renditioned him to Nigeria without any form of extradition proceedings, without the consent of Kenya, in complete violation of the Kenya Extradition Act and the Nigerian Extradition Act and the African Charter on Human and People's Rights Ratification Enforcement Act, CAP A9, Laws of the Federation of Nigeria 2024, and produced him in court on the 29th of June 2021. In the light of the decision of the Supreme Court of Nigeria to the effect that Onyendu Nnamdi Kanu was kidnapped and abducted from Kenya, any publication, report, or statement referring to the blatant kidnapping of Onyendu as rearrest is deliberately, willfully misleading the general public, contrary to the ethics of journalism. We therefore urge our ladies and gentlemen of the press to act professionally and in accordance with law, and where necessary, correct the impression before the public. The continued detention of Onyendu is illegal and without the backing of any court of law. It is noteworthy that Onyendu's continued detention at the Department of State Security Service is illegal and not predicated on any court order. Recall that Onyendu was remanded on the purported belief that he jumped bail. By the decision of the Court of Appeal, all the charges for which Onyendu is being tried were quashed for want of jurisdiction and the violation of the Extradition Act of both Kenya and Nigeria. Justice Nnamdi of the Court of Appeal, Abuja Division, unlawfully granted an order staying the release of Nnamdi Kanu. This order was illegally granted, and never in the history of any country's jurisprudence had an acquitted person been denied his release from detention by way of stay of execution. It has never happened anywhere in the world. Nnamdi Kanu offers 1 million naira to anybody, including students, who finds any judicial authority in support of Justice Nnamdi's tsunami in granting stay of release of an acquitted person. Nnamdi Kanu is offering 1 million naira to anybody who can bring any authority whatsoever to show that an acquitted person can still continue to be remanded in detention. Nnamdi Kanu pledges to give any law student in any Nigerian university, and indeed any other person, the sum of 1 million naira if such student finds any precedent on stay of execution in criminal proceeding where an acquitted person is by such order restrained from enjoying his freedom. It is an illegality that would haunt Nigeria for a long time to come. But then it was granted because Nnamdi Kanu is of the Igbo extraction and must suffer, notwithstanding what the provisions of the laws are. On the part of the Supreme Court, Onyendu Nnamdi Kanu did not jump bail, but rather ran away from the treacherous acts of Operation Python Dance to save his life and physical well-being. At page 10 and 11 of the Supreme Court findings and decisions, it was held that the respondent was on bail and therefore in the custody of the law when his home was illegally invaded by heavily armed military officers of the appellant, causing him to flee from his home and country to secure his life. In the face of such an attack, it was reasonable for him to flee to secure his life and physical well-being. That is what any normal and reasonable human being would do in that circumstance to preserve his life and physical well-being. The High Court in Enugu State, in suit number E20/2023, between Nnamdi Kanu versus Federal Republic of Nigeria and 4 others, delivered on the 26th day of October 2023 by Justice A.O. Onovo, in the enrolled order of his judgment declared thus, that the practical application of the Terrorism Prevention Act and the executive or administrative action of the respondents, which directly led to the proscription of IPOB and its listing as a terrorist group, said IPOB being comprised of citizens of Nigeria of Igbo and Eastern Nigeria ethnic group, professing the political opinion of self-determination, and the consequential arrest, detention, and prosecution of applicant as member/leader of the said IPOB is illegal, unlawful, unconstitutional, and amount to infringement of the applicant's fundamental right not to be subjected to any disability or restriction on the basis of his ethnicity as enshrined and guaranteed under Section 42 of the Constitution of the Federal Republic of Nigeria, 1999, as amended.